We have lunch? Okay, ladies and gentlemen, we're going to break for lunch. Be a 1 hour break. So all rise. Maybe okay, going back to, again, this most recent series of objections as well as the sidebar. Mr. Nelson, why don't you go ahead? You can make a record as to what it is that you wish to elicit and why. And then Mr. Hahn will have an opportunity to, I guess, make a record as it relates to his objection.
Judge, on redirect, the state asked questions getting into information that the witness said he didn't know about. I objected. They talked in general terms about that. I said once they go into that, I should have the opportunity on recross to then speak about that same subject in a manner in which he wouldn't know or how a person was supposed to respond. The state went into that. I tried to ask those questions. I was shut down from asking those questions. I think it's relevant information. The state asked questions that left an impression from this witness that a woman who has been assaulted would be able to or should know or needs to respond in a certain way, either in the event of a second assault or in the event of an investigation of a second assault. It was not clear how that was done on redirect. I was trying to clarify that. I was trying to follow up on that. My cross-examination of that witness was cut off. I believe, I appreciate Your Honor's ruling, but I'm just making my record. I believe that it was impermissibly cut off, that I should be allowed to cross-examine that witness on what he did and didn't know, and what to clear up any negative inference or any implicit argument that the state, I think, was making in which a woman who's been a victim of assault first needs to respond later on in a particular manner.
Okay, Mr. Hahn.
There's been a lot made about whether or not female officers should have been involved in the interviewing of Ms. McCandless, including through this witness. And I was simply making that point that resources were made available to her. And when I thought that defense exceeded the scope of that questioning and was entering a place of speculation as to what sexual assault victims in general are required to do or consistently do, I objected.
Just so it's clear, Judge, I never made any reference to female officers. I never said anything about a female officer. I laid out the facts. And the facts was, eventually, 2 women from victim witness came there. I didn't say why weren't they there before. I didn't leave any impression that there should have been a woman. I didn't ask him about female officers. I never went there. That wasn't a part of my cross-examination in any way, shape, or form. I laid out the facts that he spoke with her, and Jason Mengel spoke with her, and then people from the crisis response team showed up. There was no implication about lack of female.
Judge, if I could just be briefly put on that. There's certainly an implication in the context of the other witnesses that have been cross-examined by defense counsel, and the emphasis on, and then 2 women showed up to speak with Ms. McCandless is certainly at least implying that there was an issue with the gender of the officer conducting the interview, or at least that there should have been a possibility of a woman being involved.
But the question that was then asked was, does Ms. McCandless, would she have known she could ask for a women officer? And that wasn't part of my cross, and there's no basis for them to ask that question when we don't know what the victim witness people told them. We don't know what told her. We don't know that they ever said, hey, if you're ever being interviewed by a male, you can speak with a female officer. She didn't speak with a female officer. She wasn't offered that. She spoke with other females about other matters that weren't part of the investigation, that were part of the support. So I think that misleads, misconstrues what the evidence was.
All right, well, in the sidebar, you mentioned also, Mr. Nelson, that this was burden shifting and so on and so forth, and the implication of your arguments has been, going back to this line of questioning, this witness was called to present facts, and you began going into, again, on your, I believe it was your cross-examination into areas about trauma training and so on and so forth. And again, based upon, as Mr. Hahn had indicated, the context of other witnesses, there's this implication or suggestion through your questioning, it appears to the court that the Eau Claire Police Department, male officers were insensitive to issues of trauma, not trained in trauma, didn't have a female officer, although you didn't say that. And it just, in the court's opinion, you're getting beyond appropriate cross-examination of this particular witness and using him for something outside of what he was called for. And in the court's opinion, waste of time, sort of confusing the issues. And the court did not see here that the state was suggesting, or that this witness was suggesting, that this is how a person should react, or in the future, if there was another assault, the officer is simply testifying that resources were provided, that a procedure was followed to have a crisis response team in a sexual assault situation come in, and he's offering services. That's all that happened, and I don't think we need to go beyond that. In the court's opinion, it's a waste of time, and I didn't want this officer, again, to be used as part of an overall campaign in this trial about how Ms. McCandless was mistreated because of male officers interviewing her about a sexual assault.
There's no campaign on the defense that Ms. McCandless was mistreated. The state, as part of their theory, is alleging that Ms. McCandless shouldn't be believed because she didn't initially disclose this. It's the state that is attacking her credibility, and the defense is simply saying, here's some things that you should consider. We're not blaming anybody. We're just laying out facts. So we have not been on a, I can't remember what Your Honor just called it, but a campaign.
Well, maybe
respectfully disagree with that.
Perhaps a better term could be used. But this witness, this evidence is, as Mr. Nelson, you very well know, is offered for purposes of the background and the facts and circumstances surrounding the weeks that led up to the event on March 22nd, 2019. This is not being received simply for to show that this was a false report of a sexual assault. The facts are what they are, and this witness is just a background witness, panorama witness, and so it limited your inquiry into those particular areas on this witness, and it's just as simple as that. All right, now that takes care of, I believe, that sidebar, unless there is anything else that you would like to say about that.
No.
All right, there was I think we can address other sidebars later. I think we're going to recess for lunch. All right.
I believe after lunch, the state manager calling Julia Post prior to the jury coming back after lunch, the defense would, just like an offer of proof, there's, maybe we can do it on the side. I don't know what she's going to testify, but certainly her previous interviews have contained lots of inadmissible evidence. So perhaps we'll just discuss it with them, but.
Judge, I can move this along. We're not calling Julia Post.
Fair enough.
The next witness will be Jason Mengel. We do have some legal issues that need to be sorted out, I think, relatively quickly. Attorney Vishny's handling that, and she's not here, so I can meet with her briefly over lunch and finalize exactly what we have to address, and we'll bring it to the court.
Very good. Okay, we'll be in recess until...
Sorry, just two more things. Court TV stopped me. They want a copy of the journals. I told them to talk to the court about it. As well as we haven't discussed the cautionary instruction regarding this other acts evidence. I'll leave it to the court as to, just wanted a reminder that I didn't know when you were intending to instruct the jury regarding, it contains some information relating to the John Hanson matter, so I didn't know when Your Honor was going to, or if and when Your Honor was going to give a cautionary instruction.
Well, the cautionary instruction is for the jury, not necessarily for those who are watching a public trial. Those exhibits are public exhibits and exhibits.
They won't be ready until after the trial.
Well, okay, so I'm sure that the council will be referring to these exhibits and the content of these exhibits in closing arguments. So, all right, we're in recess until 1:20. Okay. You'll have a moment. I have a couple things. We're back on the record. Okay, during the break, learned that there's a request from the media for the exhibits related to the journals that were sort of privately published to the jury, and specifically exhibits 365 as redacted and 366. And the court was anticipating that to be published by the state through the media presentation, and it was not. There were copies of that exhibit, both exhibits provided to the jury. But in the spirit of Wisconsin statute section 757.14, which requires the sitting of every court to be public, as well as the state of Wisconsin, or State Ex Rel Lacrosse Tribune versus Circuit Court for Lacrosse County case. That's reported at 115 Wisconsin 2nd 220. It's a 1983 case. In the court's opinion, and I just sort of a personal editorial, one of the reasons that I pressed for confidence monitors in courtrooms and screens was because if those attending or if the media can't see the exhibits, then it really isn't a public trial. There are reasons to keep some things from public view for avoid undue embarrassment or humiliation, or there's frankly some inappropriate content. Specifically, those exhibits with showing the private genital areas and so forth in the folders. That's not going to the media. I think that is appropriate. I think it was described. There were drawings. However, the court believes that those exhibits I've just referred to, there's no reason that they should not be provided to the media. We're not going to be in a position to honor public records requests generally during the course of this trial, but because the media does hold a special place recognized in the law because they are reporting on behalf of the media, on behalf of the public, the court is going to order that those exhibits be provided to media covering the trial if they request. There's also a request for the three exhibits related to the DNA analysis. As it relates to those exhibits, we have not yet come up with a redaction. My thoughts at this point in time would be that if on Exhibit 554, which contains the portions where there was considerable argument and a stipulation, that the text in those sections and the corresponding letters or item numbers, that essentially that area be whited out and the word stipulation be put in its place. And I just want council to think about that, but I'm not going to have those exhibits released until we do come up.
Your Honor, there's a number of other tests that were done on other items that were submitted for evidence that were not brought up. They're not really relevant to this case. They weren't testified about. There was, so I think those items should also be redacted, the ones that were not testified about.
All right, and I think what I'll do is give, again, the parties, because this has come up on short notice, but I'll give the parties an opportunity to think about that overnight in terms of an appropriate redaction for those exhibits. But I believe that those parts of the exhibit that were received in evidence in one way or another should be provided, will be provided to the media with appropriate redaction. But we obviously don't have time to do all of that right now. We have to keep this, keep the trial moving. And so, are we ready for the next witness?
We have a couple legal issues that we needed to address before
All right.
Mr. Mengels called. First, I just wanted to let the court know, I think there was a misunderstanding of what Attorney Nodoff was mentioning prior to our break about a cautionary instruction as it relates to other acts evidence. It was mentioned in the context of court TV. There were two separate thoughts, however. The cautionary instruction was whether or not an instruction should be read because we just heard some what would be considered other acts evidence. But as long as it's on the court's radar, I know we haven't sorted out what exactly the instruction would be. I think the state is fine having that read later as part of the broader jury instruction reading to the jury.
All right, Mr. Nelson? Ms. Fishley?
I'm sorry, Judge, I was looking for something, I didn't think it was pertinent to what I was doing.
All right, well, there was,
I wasn't listening.
there was some discussion about a cautionary instruction. And obviously, a jury will be given instructions at the close of the case. I have improvised one instruction basically as it relates to what evidence is, so they would have some idea of that before before the court advised them of stipulation and judicially noticed facts. However, we've now gone into what would be considered other acts type of evidence. And panorama evidence is sort of a special part of that. It's a little bit different, but the same analysis, I think, applies. But no cautionary instruction has been provided to the jury on why they are hearing that evidence. Does the defense request that there be some sort of instruction given before instructions at the close of the case?
Yes.
Not right now.
All right, then that's something we'll take up.
However, at a later time, and I haven't, did you provide us with a draft of what you wanted?
No, and we have not. It wasn't something we were pushing to have done now. I just wanted to make sure that the court was aware of it, so defense was able to have input on whether or not it should be read now or read at a later time.
We should definitely take that up. I just don't think I just was ready to take it up right now, Judge.
Very well, so that's just to give you a heads up that we will take that up. And I think periodically it's not a bad idea to do that so that they get some understanding of why they're hearing that evidence. And
Okay. Judge, I just need to talk to, I'm a little confused about something. If I can just talk to Mr. Hahn for a minute before.
Go ahead.
Objection on the record. I apologize. I feel like I might.
Which one are you looking at?
The state gave me, Mr. Hahn was kind enough to give me some exhibits in advance that he's going to use. I'm not seeing them, so I asked Mr. Maxey to see if I left them in the other room, Judge. But regardless, I can put an objection on the record or ask for a ruling right now on another matter, which is the state has advised me that it intends to introduce various things that were, can't find it? No, I don't have it. The state intends to use various pages of screenshots that I believe, and Mr. Hahn should correct me if I'm wrong, there are some screenshots that Jason Mangle took of Ezra McCandless's iPod or of her Instagram account, no matter what the device was. And the state intends to enter them as an exhibit. I don't know if there's, are these numbers on the bottom of the page, different exhibit number for each?
Yeah, it's 473 through 476.
Correct. And I think what I'll do is just give them to Your Honor to look at for a minute, so you
Right.
can see what I'm talking about.
okay, so these are sort of hand numbered, they haven't been numbered.
They're hand numbered with the exhibit numbers that the state intends to introduce. So basically what this is that my understanding is that Mr. Mangle looked at Ezra McCandless's Instagram and screenshotted these from her Instagram. The people who are purportedly talking on those Instagram pages, as I understand it, are John Hanson and Ezra McCandless. And this content, which is on there, can best be described as flirtatious. I'll just use that word for right now, between Ms. McCandless and Mr. Hanson. And I am objecting to the relevancy of those messages that were between these two individuals. First of all, as to Mr. Hansen, the state has chosen to not call Mr. Hansen. I've been told he's not being called as a witness, possibly in rebuttal, but not in the state's case in chief. So anything that Mr. Hansen says is hearsay. Now, I'm going to anticipate that the state is saying that they are only introducing Mr. Hansen's statements in order to give context to Ms. McCandless's statements. Therefore, I continue my objection to argue that Ms. McCandless's flirtatious statements towards John Hansen do not belong in this trial in the state's case in chief. The court has ruled that Ms. McCandless's sexual conduct with Mr. Hansen is permitted as panorama evidence, and we have had evidence of this both through Officer Vang, who took a statement from Ms. McCandless, and I think probably more central to the prosecution's case, the journals Silence Broken and Journal 2, which the state opines is some evidence of Ms. McCandless's emotional turmoil. And as I understood the court's ruling, the court permitted that to be proffered in the state's case in chief as evidence of Ms. McCandless's state of mind, emotional turmoil, and panorama of the events leading up to Alex Woodward's death. However, her specific flirtations with John Hansen and her comments do constitute other acts evidence. My understanding is that the state attempted to proffer these in its case in chief as some kind of evidence that Ezra McCandless was not truthful about what she said to the police about what happened sexually between her and Mr. Hansen. My understanding was the court was not going to allow evidence to be elicited for any purpose of arguing that Ms. McCandless was not credible or purportedly had made some kind of false claim of sexual assault to the police. So I can't frankly grasp what is relevant about her flirtatious texts to Mr. Hansen, which were screenshotted by Jason Mangle, how that helps to prove or disprove a fact and issue in this particular case. These are matters between her and Mr. Hansen, this flirtation. This has nothing to do with what happened between her and Alex. If the state is arguing these go to her credibility, she hasn't testified in this case at this juncture, and they simply should not be permitted into evidence. That's my argument.
Okay, who would like to handle that argument for the
I
state?
will, Judge. First, as to the hearsay, they're not being offered, Mr. Hansen's statements are not being offered to prove the truth of the matter asserted, so I think that's pretty clearly not hearsay. If the court finds that that it is being offered for the truth of the matter asserted, those are adoptive admissions by the defendant by acknowledging and responding to the statements that are made by Mr. Hansen. And really, it's this is a segment of what was included in the defense filed a motion in limine trying to exclude all of the messages contained on Mr. Hansen's or provided by Mr. Hansen as it relates to his relationship with the defendant. These are only a portion of those because this is what was pulled from Jason Mangle's phone, not the entirety of the messages John Hansen provided. The court has found that the relationship between the defendant and Mr. Mangle, as well as the defendant and Mr. Hansen, is relevant to this case for certain purposes. And these messages are how Mr. Mangle came to be aware of the relationship between the defendant and Mr. Hansen when he observed these and then screenshotted them on his phone. They were initially observed on her phone, and that's why he saw them and took photographs. The messages come after believed date of the sexual encounter that we've heard a little bit about, and I expect there will be more testimony about, between the defendant and Mr. Hansen. So I think it shows, it's relevant for a number of purposes: state of mind, the relationship between the defendant and Mr. Hansen, but more importantly, the relationship between the defendant and Mr. Mengel, and the information she provided Mr. Mengel, and how that meshes or doesn't mesh with the information contained in the text messages. The defense argument that the defendant would somehow need to testify before her credibility can be attacked just certainly isn't how court cases work. Credibility of somebody who's provided statements, a defendant who's provided statements to law enforcement or anybody else prior to trial, and those statements are being admitted, those statements can certainly be attacked on the credibility basis. So she doesn't have to testify before her credibility becomes an issue as it relates to statements she's made prior to trial. So I think, one, it's not hearsay; two, it's relevant, it fits within the provisional rulings of the court, and three, I think the credibility issue doesn't have to be addressed only once she testifies.
Judge, if I can just very briefly respond to the state's argument.
Go ahead.
What I would like to say is, do I think that, for example, her statements that she gave Investigator Prock or Detective Prock regarding what happened with Alex, that they can show that there are inconsistencies or differences of things she said to him? Yes, of course they can. But this is just for a general attack on her credibility as a person. And that kind of general attack of a witness who testifies for truthfulness may be inquired under 90608 sub 2 upon cross-examination of a witness, and when they are questioned about matters related to their truthfulness as a witness under 90608 sub 2, the cross-examiner must, quote unquote, in the words of M. Winklereed, take the answer. That's a pretty black letter law. So I would argue that these are for a general attack on her credibility, not her statements regarding the alleged offense in this case, the homicide of Alex Woodworth, number one. Number two, if the evidentiary purpose for the state is to show that this created a fissure or a problem in her relationship with Jason Mengel, which was part of her state of mind, which is what the state argued in its opening, then all the state has to do, and I would not object to them leading, is say, you read her Instagram, there were some things that upset you. Through reading this Instagram, you believed that your girlfriend had sex with your friend John, and the two of you were arguing about this, and then this is what she told you happened. The substance of those actual messages, which again I argue are not relevant to anything except for Ms. McCandless's credibility, in which case she can be cross-examined, but there are extrinsic evidence on a collateral matter should not be permitted into evidence. Thank you.
All right, well, first of all, I do not see these exhibits as being 90608 sub 2 extrinsic evidence, and this is not where witnesses being cross-examined on credibility, and they're not, as the court made clear in the provisional ruling, not offered related to credibility. And however, I did say that if this panorama evidence comes in, it may have the effect, but that's not the purpose for which it's offered. Now, we have in this case already, and I'm not going to comment on what evidence may come in because it hasn't come in yet. But at this point, I think we have evidence that Ms. McCandless went to talk to Mr. Woodworth on March 22nd about her feelings. She went, and I think this came in through one of the officers, perhaps Officer Reeves. One of the things she wanted to talk about was the investigation, and the name John Hansen had come up. And the court believes that these messages are very relevant, and in particular, when you look at exhibits, the journals, refer to them by their exhibit numbers. Sorry, I don't have all of these exhibits. Exhibit 365, silence broken. Exhibit 366, Journal 2. In both of those exhibits, there is reference by the defendant to pain, regret, disgust, shame, waves of guilt, and from Exhibit 365 in particular, on the second to last page, makes reference to the extreme guilt, I'm quoting, the extreme guilt I felt because of the betrayal I had committed against the love of my life drove me to start self-harming again. I think in a nutshell, these messages are at the heart of that, and without a jury seeing the actual messages in the court's opinion, it would be difficult for them to understand the context, understand the significance of Exhibits 365 and 366. So, again, these in the court's opinion, are very relevant evidence to those very strong feelings that Ms. McCandless had. And I think that they are very relevant. I do not believe that they are hearsay. They're not offered for the truth of the matter asserted in the sense of what Mr. Hansen said, but certainly for what the defendant said as her statements. And so the court is going to allow Exhibits 473, 474, 75, and 76, assuming that's what the actual exhibit, that will be the numbers, Madam Clerk? So these should be marked as an exhibit since I'm referring to them. Otherwise, we're going to be...
Judge, I think the stamp at the bottom, it's very small, but it actually does have the court's.
Well, it has, someone wrote in handwriting the numbers, but we need exhibit stickers to correspond so that we're not...
It's very tiny above it. It says plaintiff's exhibit. I certainly think we could, I'll leave it to the clerk, obviously, but.
Okay, well, we would like to have our court exhibit stickers on these.
That's fine, those are my copies, though.
Okay,
I'm
so,
assuming the state has another copy to give the court.
well, I want to make sure that what I'm referring to, that I have in my hand, will be exactly the same as those court exhibits. So,
Judge, I can give a separate copy to Attorney Vishney if you want to keep those as what will be marked.
That would be fine. That would be fine with me.
Madam Clerk, there are numbers on them, so
Okay.
I'll give those to you. Or, no, I think Mr. Hahn is going to give them to Ms. Vishney, and we'll use these copies.
Yes, that's fine. Judge, there's one other matter. The state has another exhibit it's giving to the court, and I don't have an exhibit number on it yet. It is an Instagram business record that the state has provided me with a copy of, and it starts at Instagram page 975, and the last page number is page 983, though I will advise the court that those are backwards numbers to how the conversation actually occurred, and that the end of the conversation is actually at page 975. And I'm not objecting to the majority of this conversation, but there is one point in the conversation near the end.
Is this identified as an exhibit yet?
No.
Does the state have an exhibit prepared?
It is, Judge. It says plaintiff's exhibit 465.
Oh, I'm sorry. There's not a sticker on it, but there is something noted at the bottom of the page.
Okay, well, I would like to get these marked as exhibits before we start having extensive discussion.
That would be great. I'll just wait until it's marked and that you can see what I'm talking about, because it's a very small point.
Judge, would you like a copy?
Yes, please.
This is the one I have marked.
Sure, I'll take that one.
Okay,
Madam Clerk, let's mark these. This whole packet would be Exhibit 465.
yes.
Okay. We'll have it marked first.
And I
Okay, go ahead, Ms.
I have an apology to Mr. Hahn, because I hadn't caught this until just now, and I don't even know if he would agree to take this out. But if you look on page 976, which is the second page, and the conversation begins at the bottom of the page with, "I doubt he'll get a word in." And Judge, so if you look at page 976, if you go up almost to the top, Jason sends a text to Ezra and says, "Don't use racial words in text ever." And I really don't know what this refers to, because the only racial word that had been used had been previously by Jason. "You talk like Rican," or however that's spelled, but I'd ask that that be deleted. I don't understand it, but. But some kind of implication that Ms. McCandless was saying something racial, or I don't know if you meant to say racist, but it just seems kind of irrelevant and inappropriate to me.
Well, there's,
And I,
on that page, just below the middle, there's a text. The author of that is, assuming that that's Mr. Mango, says, "You talk like," and then continues. Can you see that line?
yes, and is the author of that,
And if, Judge, before we state the author, the Instagram name on the record in open court, I would like to take some precautions to make sure that those aren't included as well. So I think if we can agree, I think Attorney Vishny and I know who Mr. Mengel is in these conversations, so I'm fine if she just refers to that being Mr. Mengel's conversation.
All right, so,
I think it's his unless I have it wrong. Mr. Hahn, if I have it wrong, I believe the person whose name appears as the author directly under that line is the author.
It is,
Am I
Judge.
correct?
Yes.
Okay, so the author is Jason Mengel. And by the way, Ms. McCandless's Instagram name was used by the state in its opening statement, and it's in evidence. So I see no reason why Mr. Mengel's Instagram name should not be allowed in evidence. It doesn't have his actual real name. It's a pseudonym or an Instagram name. And I see no reason why it should not be permitted.
well, the question isn't whether it will be permitted. The question is whether it's something that's going to be subject to being broadcast.
Oh, okay, but we can use it in front of the jury. It's just that Court TV can't broadcast it?
Well, I'm not going to tell them what they can or can't broadcast. It's a public trial. I mean, that's,
Okay.
folks, as much as people would like to do things in private, we don't do things in private. So, again, we'll protect personal identifying information. Again, a phone number is one thing. Mr. Mengel complained that he was getting text messages and calls and so forth. But Instagram names, and I'm sorry, I'm not that familiar with how Instagram works. But if someone knows someone's Instagram account, how can that be harmful to them? Is it going to blow up their account?
Judge, I don't have Instagram, but I believe it's essentially the new age telephone number. So somebody who goes on Instagram could send messages just like they could a text message directly to that person. And if somebody knows better, they can correct me, but
I think there's privacy controls that somebody's able to just make their account private, and so it's certainly within the control of the account owner to decide whether or not they want to open it to the public or not, and so it's.
All right. Well,
and if I could, Judge, the only reason I'm bringing this up now, and it wasn't raised before opening statements, is because we didn't have the issue with Mr. Mengel being contacted by however many people contacted him until after opening statements were made.
Well, I understand. It's, so it's just something I think, you know. we
Right,
have
but
to
you
watch.
can set your account to private. You can choose to use your own name, you can use a pseudonym, you can have it set to private, people can't find you unless you friended them. That's what happens with Instagram, just like Facebook. You can set Facebook to private, and people can't see what you're posting on it.
All right, so where does that leave us then? Is the state requesting that? I mean, it'll be on the exhibit. It is on the exhibit. I guess we've already have Ms. McCandless' name on there. And I believe in other hearings and other exhibits, we have that Instagram account for Mr. Mengel. So frankly, I'm just going to let that go then. We'll have the records be as they are, and he can adjust his privacy settings. So I don't see it as the same as a phone number or date of birth or address, physical address. Okay, with that, are we ready for Mr. Mengel?
Judge, I don't know that the issue with the,
I don't think we resolved the issue, that's right. So what is the issue, Ms. Vishny? What is it that you're,
I'm asking for him to not chastise her about being racial.
Judge, and the way I read it is that he's basically acknowledging to himself, he used a racial word
Oh,
and he shouldn't, he's basically saying, oh, whoops, don't do that. That's how I read it.
if that's what he's going to testify to, I don't have a problem with that.
That's what I
I thought
anticipated.
he was saying that Ms. McCandless was doing that.
No, I don't believe that will be the testimony.
okay,
If you want to ask him before we start, that's fine. I don't have an issue.
no, issue, as far as I'm concerned, issue is resolved.
All right.
Let's get going.